There's a very specific and completely understandable moment during early separation conversations. It's when a parent realizes they just do not want their kids having to pack a bag every single week, shuttling back and forth between two homes. They want the children to stay put. And they start to wonder, should we be the ones rotating in and out? It's a beautiful sentiment, but it raises a critical legal question. This explainer covers whether DC courts actually approve nesting, what it costs, and exactly how to end it if it stops working. Because, look, once you start sketching out this idea, the practical and legal questions begin to stack up fast. First and foremost, you're going to wonder about the court's perspective, right? Will a DC judge actually mandate this kind of stability, or does it entirely rely on perfect cooperation from both of you? Then, the financial reality hits. Maintaining the family home while also paying for separate living spaces creates a huge burden. You have to ask yourself, exactly what is that premium going to cost you every single month? And you really have to think about sustainability out there in the real world. Is this a permanent lifestyle change or just a temporary bandage while the dust settles? Right, and what about the legal math? When you're both sharing the mortgage and maintaining equal time in the family home, it introduces some pretty serious complications into the DC income shares model for calculating child support. And frankly, what if the whole thing just falls apart? If the tension gets too high and that shared household turns into a battleground, you absolutely need to know how to cleanly exit the arrangement without dragging your family right back into a messy, ground zero custody dispute. Finally, there are the long-term assets to consider. If one parent spends years as the off-duty nester, living in a separate apartment, does that jeopardize your capital gains exclusion when it finally comes time to sell the marital home? Okay, let's dive into this and tackle that very first question about court approval. Here is the reality. DC Superior Court will only approve a nesting arrangement when both parents explicitly agree to it. It absolutely requires a detailed, voluntary, written parenting plan. Judges in DC almost never order nesting when parents disagree. And the reason is simple. Nesting depends on a level of ongoing cooperation, communication, and shared household management that the court literally cannot force upon two people who are actively separating. If you can't voluntarily agree on the rules, the court is just going to default to a standard schedule. So, traditional joint custody means the children move between two separate homes, one for each parent. Nesting entirely reverses that model. The kids stay in one stable residence, and the parents do the moving. But to pull that off, you're now forcing the family to maintain at least three separate households. You have the primary family home, plus a separate residence for parent A when they're off duty, and a separate residence for parent B. Now, maintaining three households is incredibly expensive. In Washington, D.C., a nesting arrangement runs between $9,600 to $37,800 more per year than a traditional custody schedule. And honestly, even if you try the budget version where both parents share a single off-duty studio apartment, which, let me tell you, brings its own massive privacy challenges, you're still looking at nearly $10,000 in extra annual overhead. This is exactly why you have to go into this with highly realistic expectations about your post-separation budget. So a crucial point here is understanding what happens legally if that financial burden becomes just way too much, or the cooperation completely breaks down. Under DC Code Section 1694, there is a rebuttable presumption that joint custody is in the best interest of the child. Now, this is highly protective for parents who want to try nesting. If the nesting arrangement fails, this code ensures that the court simply shifts your family over to a standard joint custody schedule. The judge doesn't just throw out your joint custody rights altogether just because an experimental living arrangement didn't work out. Let's move to the timeline and see how this actually plays out in practice. Because of those intense financial and emotional pressures, most DC nesting arrangements really act as a transition phase, usually lasting only 6 to 12 months. It's often used to allow the kids to finish a school year or to give the parents time to prep the marital home for a sale. Actually, fewer than 15% of families keep a nesting arrangement going past 18 months. It's meant to be a bridge, not a permanent destination. By the way, if you are currently in a nesting arrangement and you need to know the exact notice period you should give your co-parent before ending it, because springing it on them abruptly is a terrible idea, the full article is linked right down in the first comment below. When you do reach the end of that bridge, ending nesting cleanly requires a very specific legal process. You can't just change the locks. You have to file a motion to modify custody with the DC Superior Court, which comes with an $80 filing fee. But most importantly, you have to demonstrate to the court a substantial and material change in circumstances. Fortunately, showing the court that a temporary nesting arrangement is no longer financially sustainable or that the transition period has successfully wrapped up typically meets this exact legal standard to justify changing your existing order back to a traditional schedule. Ultimately, nesting can work wonderfully as a short-term bridge to protect your children from immediate disruption, but it only holds up in D.C. Superior Court when both parents plan it in writing and go in with highly realistic expectations about the financial cost. If you're deciding whether nesting fits your family right now or whether a traditional schedule makes more sense from the start, the full breakdown, including those child support implications and tax problems we touched on, is in the first comment. Subscribe if you want more D.C. family law guidance without having to go looking for it every time. So look closely at your budget, look honestly at your ability to communicate with your co-parent, and ask yourself, is this a bridge we can successfully cross together?